Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss a case law on the doctrine of proportionality. The court cannot convict one and acquit another if the evidence is same on both the persons. If the evidence is on the same lines, either the court has to convict both of them or has to acquit both of them, but cannot convict one person and give acquittal to the other. Please remember, the cross line is evidence should be the same for the same persons. This is what happened in the case of Javed Shaukat Ali Qureshi. Javed Shaukat Ali Qureshi versus State of Gujarat in criminal appeal number 1012 by 2022, decided on 13/9/2023 by two judges bench, Honorable Justice Abhay Srinivas Vokha and Sanjay Karol. So they clearly held that when once a person is acquitted, and if the evidence on the same person is also on same lines, even though he doesn't appeal, he doesn't come to the court, this law or the doctrine of proportionality applies to them also. Right? Now, during appeal filed by A6 in a particular case, the appeal was allowed. At the same time, A2 and A3 were also on the same footing. Therefore, even though they did not prefer appeal, they were released. So their case was also considered. This is the crux of the problem. Now, let us go to the case facts. This happened in the state of Gujarat, in Ahmedabad only. On 7/11/2003, at about 10 a.m., a Gori group of, or a mob of 10,000 to 1,500 people, they gathered in Shah Alam area of Ahmedabad. You may be knowing who are they. Shah Alam area of Ahmedabad, they have gathered. Right. Now, when a person by name Baldev, he became PW1 in this particular case. When PW1, Baldev was passing on his two-wheeler at that along the Shah Alam area, these people found him to be belonging to another religion. They have accosted him. He has told his identity. He has told his religion. Then they assaulted him like anything. Right? The crowd stopped him and assaulted him and even burned his scooter. This melee continued for some time more. In the meantime, an auto rickshaw came. They stopped the auto rickshaw. They asked the passengers to be alighted from the auto. One of the women, when she resisted or when she was getting down, these people snatched away her gold chain and damaged the auto and later some other vehicles also. Right, this is the case facts. Now, the police registered a case under sections dacoity 396 IPC, attempt to murder 307 IPC, 435 because they have burnt the scooter, 435, that is mischief by burning. So 435 and so many other cases were added. Anyway, dacoity is the most important case. So the trial went on and ultimately some of the accused were acquitted, particularly A6, A1, A13, A2, A3, all of them were convicted. Right? They went to High Court level, even High Court also dismissed the appeal and they were said. So of course, High Court was considered to consider the appeal of some more persons. But they did not allow the appeal of A6. Now A6 has come to the Supreme Court. Here, the evidence against A6 is only PW2. So the other part, that is advocate on behalf of the appellant, he stated that she doesn't have any contact with him previously. That means she does not know him previously. Her identification is vague. Except her, the other witnesses did not identify. So many things he has told. The court was convinced that the identity is not proper. Okay, the appeal allowed and the conviction against him is set aside. At the same time, another point came to light before the Supreme Court that A2 and A3 were also convicted basing on the same evidence. Of course, on the evidence of PWS 25 and 26, same lines. So this is also, the identification is not wholly reliable. Wholly reliable, partly reliable, like that in Evidence Act you will be coming to know. So therefore, they applied the same principle, applied the doctrine of proportionality, because justice should be proportional, should be equal to all. So they have also given their contention was also allowed. The funniest part is they did not file at all an appeal, but during the course of the trial or the so-called appeal stage, the Honorable Court came to know, and using their powers under Article 136 of the Constitution of India, Honorable Supreme Court of India was pleased to take up their appeal and allow them also. Now, with the help of A6, even though A2 and A3 did not file the appeal, they came out free. So this is what is important in the particular case. This is what is called doctrine of proportionality. That means the court cannot convict one person and acquit another person basing on the same evidentiary lines. If you know this much, it is sufficient. Thank you.